Your Honor, we're also approaching on bail, being that we do have a recantment, and the recantment was pretty quick.
A man already on bond for assaulting his wife is back in court, but this time it's even worse. He's picked up not one, but two new assault charges, one against his wife again, and the other against her 16-year-old brother. But his defense has a bombshell. The wife has completely recanted her story, claiming she made it all up and was worried about being charged for a false report. Is this a man wrongfully accused and attacked by his in-laws, or a master manipulator who has coerced his victim into silence? The judge is about to make a decision that will leave everyone in the courtroom speechless. Let's break it down.
And the complainant is also asking for a dismissal. We're going to ask for a PR bond on.
You are on bond for an assault of a family member from April, and now you've picked up two more assaults of a family member. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
One of the complainants and the defendant are married. On November 2nd of 2024, officers were dispatched to an assault at a residential home in Harris County, Texas. Officers met with the complainant, who stated that she and the defendant have been common law spouses for 9 years, and that complainant and defendant were at complainant's father's house having a party. The complainant went to move their car so a guest could leave. The defendant became agitated and left. The complainant caught up with him, and he was laying down on the ground. The defendant grabbed the complainant's hair and struck her with an open palm to the face. The defendant stated, "There's no mark, so there's no proof I hit you." The complainant stated she felt pain. Complainant 2 is the brother of complainant 1 and is 16 years old. Complainant 2 stated he saw the defendant cause the scene because of the vehicle being moved and observed the defendant cursing and screaming at complainant 1. Complainant 2 heard screaming and went back outside. The complainant 2 saw his dad holding the defendant by the wrist while on the ground.
Let's pause and unpack these allegations because they are chilling. The defendant allegedly became so enraged over a car being moved that he assaulted his wife, and his statement, "There's no mark, so there's no proof I hit you," is incredibly telling. That's not something an innocent person says. It suggests he's aware of how to inflict pain without leaving visible evidence for law enforcement. Then, the situation escalates to him allegedly striking his wife's 16-year-old brother with a closed fist. This isn't just one moment of lost control. This is a pattern of aggression against multiple family members, one of whom is a minor. The prosecution is painting a picture of a man who is volatile, violent, and a clear danger to this family.
On the ground. The defendant's parents.
So the son sees him holding the wife down. Is that what you're saying?
No, Judge. I'm saying that, so the brother, complainant 1's brother, saw his...
Complainant 1 being the wife.
Yes, complainant 1 is wife, Judge.
Brother.
So complainant 2 saw his dad holding the defendant by the wrist while on the ground. Defendant's parents are called, and the defendant was let go. The defendant began to yell and scream at complainant 2 again, and then lunged at complainant 2's dad. Complainant 2 got in between them, and the defendant struck complainant 2 with a closed fist to the side of his cheek. Complainant 2 struck the defendant once back. Officer stated a reasonable person would feel pain after being struck in the face, so he struck complainant 1 with an open palm and complainant 2.
Now, the complainant in the first assault, who is that?
Judge, it's Christian Martinez. So there are two complainants in the other assault.
This is my wife, Your Honor, Stephanie Martinez.
Do we need your help? You're in enough hot water as it is, Mr. Mancias.
I understand, sir.
So it was the wife, Judge. So there are two.
So she gets another round, right?
Yes.
The new case is against the same complaining witness.
And there are 3 open AFMs now in total.
What is the one thing I asked you not to do?
I understand, Your Honor.
Was there no protective order at the time?
There was a protective order, Judge.
This is the moment the entire case flips on its head. A protective order was already in place. This means a judge had previously determined this man was a credible threat to his wife and legally ordered him to stay away from her. Yet, here he is at a family party with her, now accused of assaulting her and her brother. Violating protective order is a massive offense in itself, and it shows a complete disregard for the court's authority. The judge's frustration is palpable. He isn't just looking at 2 new assault charges. He's looking at a defendant who brazenly ignored a direct legal command designed to prevent this exact situation. How can a defense possibly argue for a PR bond now?
They said that they were having a celebration at the dad's house. So I would imagine, but I can't say.
This was initially sent to the ERD, so I want to keep it again. We're going to keep it. Okay. Mr. Macias, I'm going to find that you are a complete and utter danger to my society. And there's only one thing that we do. Guess what happens now? I'm entering now magistrate orders for protection on both of those people. And I'm ordering you not to have any contact with either of these people. You violate these conditions, I will have a hearing as to whether I'm going to hold you at no bond.
Yes, Your Honor.
Do you understand?
I understand, sir.
I'm also now going to put a GPS monitor on you so I know where you are at all times. And I'm ordering you not to consume alcohol or illegal drugs.
Understood, sir.
You understand?
Yes, sir.
Any more issues, I'm going to make your bond so high you'll have teeth falling out.
Yes, Your Honor.
Goes with you.
May I make one statement before?
No.
Stephen sign.
Jesus Macias, Your Honor, this was the one that was up here a little earlier.
Is it, you said?
Macias, he's the one that picked up, I just got to point it on the day.
Oh, yeah.
Yeah,
Okay.
The 2 new assaults.
2 new assaults.
Yes.
Okay. All right. So I talked to Mr. Macias for a while, and he was going to share with you a few things that would kind of help give some more context in the case. On his 2 known law violations, there was a rip call that was made to his the complainant, and the complainant basically said kind of what verbatim what Mr. Macias told me, that he was actually attacked by her family. He called 911. When he called 911, she became very upset, made up the story of the assault, never saw the brother be assaulted. So you have, on the 2 new assaults, you have brother on one, and then you have wife on the other. So she basically recants and says that the assault on her never happened, and she says that she doesn't witness anything as far as with the brother. Okay, those are the 2 new law violations. She also makes a reference to the first assault, which he's currently in the court as well, and says that that was made up as well. Now we have people that recant all the time, but it would be.
I mean, I'm not going to take his word for it just because it's right.
Well, no, of course, Judge, but it should be noted as far as on this recantment as well, that she actually asked the state that she need representation for the false report. So that's a little bit different. That's usually, you don't usually have it to where people are concerned about getting representation for making a false report.
Here's the defense's Hail Mary. They claim the wife, the complainant, not only recanted, but is now worried about facing charges herself for filing a false report. On the surface, this sounds like powerful evidence for the defendant. But in domestic violence cases, this is an enormous red flag. It is extremely common for victims to recant due to fear, manipulation, financial dependence, or a desire to keep the family together. The defense attorney is framing this as a sign of his client's innocence, but a prosecutor and a judge will see it as a potential sign of coercion. The question for the audience is this: do you believe she's genuinely admitting to a lie, or is she being pressured to change her story to protect her abuser?
That's usually a little bit extreme, so to speak.
She's
actually asking for it to be dismissed.
He's on bond for an assault against this person, picks up another assault, right? And then another assault against another person. I'm putting an order for protection in, and I don't want you to have contact with this person. I'm still going to take you in. I mean, I have something that's said here. People recant all the time after the fact because for whatever reason, but I have something here. I think that there's enough evidence to go forward. And I think that I believe that probable cause did occur. I'm not going to take your word as gospel. I don't know. Maybe the facts will show something different later on, but the evidence is going to point to whose side is correct. I don't know. Perhaps there'll be photographs. Perhaps there'll be body cam footage of what a person looked like. I don't know. But this is stuff that we got to wait for to see what happens.
The judge lays down the law perfectly here. He says, people recant all the time, and this is a critical point. He's not dismissing the recant, but he's refusing to let it be the only factor. He's relying on the initial evidence gathered at the scene, the officer's report, the statements from multiple witnesses, including the brother, and the context of the defendant's violent history. The judge is essentially saying that the probable cause established on the night of the incident is strong enough to proceed. He's waiting for objective evidence like body cam footage, which can't be intimidated or manipulated. This is a crucial aspect of the justice system. The state can proceed with a case even if the victim withdraws cooperation, if they believe they have enough other evidence to prove the crime occurred.
But
Your Honor, we're also approaching on bail, being that we do have a recantment, and the recantment was pretty quick, and the complainant is also asking for a dismissal. We're going to ask for a PR bond on. This is the thing. I would definitely argue that there's going to be. I mean, at the very least, then, if that's the case, then I would like a speedy trial, because if we're going to,
yes, and I'd be happy to give that to you.
I would rather do that.
And I absolutely love your tenacity.
Oh, I want it. I
love your tenacity, but on the PR bond,
understandable. Well, we know that you wanted to set a bond, Judge. So
I did. I set it at 15,002 because I want you to understand that we mean business, and my utmost important is public safety, and that's the only thing that matters to me. Do you understand? And if I find that you have contact with this person, and I don't care what is going on, so help me. Do you understand?
I understand, Your Honor.
Judge, that was 15,002 on the old case.
Yeah.
And on the new cases, those are going to stay at
Leave it as
1,000.
is. I'm going to leave it as is. I'm not going to touch it what the magistrate did, but I'm just going to revoke the old one because he picked up the two new cases. I'll leave as is. Within my right to revoke it and raise it and make it higher, because I think that you're an utter danger to the public, right? I'm not going to, but understand that we can. And if I find that you violate any of these conditions, I will go nuts on the bond. Do you understand?
This is a hammer blow. The defense asked for a PR bond, which means release without paying anything. Instead, the judge revokes his bond on the previous assault case and sets it at $15,000. Revoking the bond is a punitive measure. It's the court punishing him for reoffending while on pretrial release. The judge explicitly states his priority is public safety, not the defendant convenience or the recanted story. He then leaves the bonds on the two new cases as they are, but this $15,000 is a brand new, immediate financial hurdle. The judge is sending a crystal clear message. You violated my trust, you violated a protective order, and you are a danger. The games are over. He's using his authority not just to ensure the defendant shows up to court, but to protect the victims.
Understood, Your Honor.
Okay. We've given you a lawyer. It's your responsibility to stay in touch with him. When you get out, you will have an ankle monitor, so I know where you are at all times. You're not to go within 200 feet of where she lives, or where he lives, or where they work. You understand?
I understand.
We will see where it pings at all times. So if you go anywhere near these people, get ready. I will give you the speedy trial. I need to give them at least enough time to get their evidence, to get their motions and subpoenas in line, which is at least 30 days.
And
After that,
I don't press the state. I've worked for the state before, so I can be amenable to a time that works for them. I just want to be fair to him as well.
I mean, it would be probably in January, but whatever date then, we're gold, whatever you want. Yeah, of course. All right. Thanks. Wait.
So let's recap the final ruling. The defendant, Mr. Manis, walked in facing 3 separate assault charges against his family and a violated protective order. Despite his wife recanting, the judge saw through the defense's request for leniency. Instead of a personal recognizance bond, his original bond was revoked and reset at a steep $15,000. On top of that, he is now subject to GPS monitoring with strict exclusion zones around the victim's homes and workplaces, a no-contact order, and is forbidden from consuming alcohol. The judge prioritized public safety above all else, showcasing how the court system handles high-risk offenders in domestic violence situations, even when a victim changes their story. This case is a stark reminder that the initial evidence and a defendant's pattern of behavior often speak louder than a last-minute recantation. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.